Thank you for coming tonight. I want to begin our program by first introducing our panel and thank them for participating tonight. I have a few introductory remarks, and then we're going to get into the experts, which is those folks. So first, all the way on the left there, or your right, is Satyajit Bose. He's a professor of practice in sustainability management at the School of Professional Studies here at Columbia. He's also associate director of the MS in Sustainability Management program. He's also a longtime colleague of mine in the Earth Institute's research program on sustainability policy and management, one of the world's experts in sustainability finance. Seated next to him is Celine Rubin Salama, who is a lecturer in professional studies in the MS in Sustainability Management program at the School of Professional Studies. She runs For the Long Term LLC, a corporate strategy consulting firm dedicated to long-term value creation through corporate sustainability planning, implementation, and reporting, and it works with some of the world's biggest listed companies in the tech, food, financial services, real estate, retail, and professional services sector. She's also a graduate of SIPA's MPA in Environmental Science and Policy program. Seated next to her is Taylor Pullins, who is a lecturer in professional studies at the MS in Sustainability Management program. You're noticing a theme here. She's a partner. He is a partner in the global mergers and acquisition practice of White and Case and head of the firm's ESG and sustainability specialty practice. He advises domestic and international clients in drafting and negotiating of environmental terms and indemnity provisions in complex business transactions. There'll be a quiz on what everybody does at the end of this. And finally, my colleague for many years here at Columbia in the Earth Institute and at the law school, it's Michael Gerard, who is the Andrew Sabin Professor of Professional Practice at Columbia Law School, a professor who has been in charge of the Sabin Center for Climate Change Law from its inception. And from 2015 to 2018, I actually dragooned him into being the chair of the Earth Institute faculty at Columbia University. So let me give you a little bit of the background here. Back in 2010, I wrote a book called Sustainability Management, and we started in that same year the MS in Sustainability Management here at Columbia University. What we called sustainability management in 2010 is only a piece of what is now a much more complex field of sustainability management in 2023. And today I wonder how any type of organizational management can be taught in any university without significant attention being paid to the organization's environmental, corporate, social, and community impact. The Securities and Exchange Commission is signaling this with their proposed climate disclosure rules. Now, I know that they're being delayed, but I'm one of those people who's pretty confident they're coming, but we'll see what the folks here say. According to Deloitte's website, quote, on March 21, 2022, the SEC issued a proposed rule that would enhance and standardize the climate-related disclosures provided by public companies. As SEC Chair Gary Gensler noted in his statement about the proposed rule, quote, today's investors, representing literally tens of trillions of dollars, support climate-related disclosures because they recognize that investors need reliable information about climate risk to make informed investment decisions, unquote. The European Union and the state of California have leapfrogged the SEC and already issued disclosure requirements, and we'll learn about those specifics in a few moments. Now, while the specific SEC proposal has been modified and delayed in response to thousands of comments, and ideologues in Congress will challenge the SEC in the media and others will challenge the rules in the courts, the drive behind the rules are investors, and so it's likely that some form of the rule will survive. But even if it doesn't, in addition to the SEC, the European Union and state of California have actually already acted. And so it's my hope that all of these rules will eventually be expanded beyond carbon disclosure to issues such as biodiversity, air, and water. At a minimum, the new SEC rule will help provide environmental sustainability with a role just like that played by accounting and financial management in modern organizations. CEOs today have to be able to read a financial statement. And I think the CEOs in the next decade are going to also have to learn how to read environmental impact statements. And these issues are now central to how organizations are managed. Now, the evolving field of sustainability metrics in the 2020s will resemble the development of generally accepted accounting principles back in the 1930s and continuing to the present. Now, the SEC was actually created to provide regulated and audited financial information to investors. One of the reasons we had a crash is there was no such information, and playing the stock market was like going to a casino. You never knew what you actually were buying, but there was pretty much a good chance that it was crooked. So soon, companies are going to have to comply with these reporting requirements. And my feeling about it as an organizational management expert is that in the next 10 years, chief sustainability officers will take their place alongside of chief financial officers as significant players in organizational life. So tonight, we're going to present a high-level introduction to the world of mandated corporate carbon disclosure. I've asked Professors Gerard and Pullins to briefly summarize the reporting requirements that I described before, what they require, who's required to report, and when this will take place. I've asked Professor Ruben Salama to discuss how companies are preparing to meet these requirements and how this might change the ESG reports her organization works on. And finally, Professor Bose will summarize the potential impact on financial markets. We're going to discuss after all of this whether this is actually going to have an impact on environmental quality, which is, of course, why we're doing all of this. So, Taylor and Mike, why don't you two begin by summarizing the requirements of the new law and the new rules? I think Taylor's going first. Mike's
Okay,
up.
yeah, there we go. Steve, thank you so much for the invitation to participate. It's great to be here. It's been a pleasure to teach a course focused on the SEC's proposed climate disclosure rule, where I have 2 hours each Thursday evening, and you've asked me to summarize these rules in 10 minutes. So it is going to be a challenge, and I do want to set some context, perhaps, because there's different ways of approaching these rules. Certainly there's the political way, which has generated a lot of the discourse that you see in headlines. And we're here in a position of a regulatory body, the SEC, proposing significant rule changes because our elected officials in Congress have not achieved that legislation that would have required additional disclosure or additional action by companies, and so the SEC is picking that up. Brief introductions were made, and we were asked to provide brief material for that introduction. I think it's pretty important that we are honest and accurate in that introduction, right? You'd expect that some of the credentials that you hear be reliable and be something that you can say, okay, yeah, I heard from somebody who's a partner at White & Case. He really is a partner at White & Case. In the SEC disclosure world, what I'm trying to make an analogy to is material information. Okay? Investors can rely on material information, and in fact, a company is required to disclose what is material to their business. And in the climate disclosure space, well, first of all, let me define material based on what the Supreme Court has said. It's information, any information that a reasonable investor would see as important in making decisions around whether to buy, hold, or sell securities. Okay. And since 2010, when the SEC issued guidance, so these guidelines, kind of informal rules around how a company should disclose climate risk in their securities filings, we've seen only so much progress in the content, the depth, and really the meaningful amount of disclosure around climate. That was 2010. That was a long time ago. I've watched the space. I saw a kind of incremental increase in disclosure, and then somewhat stagnation in the SEC filings. But then you see what has happened in sustainability reporting, in climate reporting, voluntary reporting by corporations. They've invested significant amount of resources, certainly dollars. They've hired a number of people, experts, to manage their data, to generate data, to make sure the best they can that it's verifiable. What drives this corporate action? It's the investor interest, the investor demand for this type of information. And the reason why I'm taking 2 of my 10 minutes, maybe 3 of my 10 minutes to set this context is if companies recognize that it's so important to investors that they have a program, have procedures to gather, vet, and disclose in an informal document, like a website or a sustainability report, this type of information, they see that investors want it. We're getting really close to that, like would a reasonable investor see this as important in making decisions, that materiality threshold. Okay? So now the SEC proposes back in March of 22, that was quite a while ago, these landmark rules, long-awaited rules that would require companies to enhance, to make verifiable, to make comparable disclosure around what is a material risk around climate change and what are the opportunities as well. How they as organizations approach risk management of climate risks, how climate is incorporated in their corporate strategy. The SEC, what they did to recognize the progress that has been made through the market, kind of self-regulation, as reflected in sustainability reports, what the SEC did to build upon that market progress, okay, is they reference in the proposal 2 frameworks that have become near mainstream. I would say one of them is mainstream and the other is pretty darn close, depending on who you ask. The Task Force for Climate-Related Financial Disclosure, TCFD, sets forward a framework which many, many companies have voluntarily adopted and made disclosure in sustainability reports on their website and climate-focused reports around 4 pillars around how they approach climate from a governance perspective, risk management, strategy, and then what are their metrics and targets. And then on the accounting side, the GHG disclosure protocol sets forward the way in which a company can disclose its direct greenhouse gas emissions, its indirect emissions in the way of scope 2, and then indirect in the way of supply chain upstream and downstream emissions, which would be your scope 3. Okay? And so the proposal from the SEC builds upon these well-accepted frameworks that companies have been disclosing upon. Steve mentioned that so many comments came in response to this proposal, to a degree that it literally crashed the SEC's system for receiving, managing, and eventually responding to these comments. First for everything, I guess. Okay. But what I've been approaching advice to clients as well as discussion in our course around these proposed rules is a typical process to run through the administrative law process from draft rule to final rule is typically less than a year. I would say many are completed in less than 6 months. Okay? You have to provide the public an opportunity to provide public review and comment, and then as part of a final rule, responses to those comments are issued. We're now beyond 20 months. I believe, and I've heard this even today from a wise person on the stage, that the SEC will issue final rules before year end. Okay, 2023 is an odd year, meaning odd numbered year. It's also been an odd year. And 2024 is a meaningful election year. And I think that there is a number of reasons to have final rules in place and to have, I guess, the discourse focus on, did the SEC have authority to issue those broadly sweeping disclosure rules? There have been, and this goes to the politicization of these rules. There already has been, in response to proposals, so a draft rule, a fair amount of finger pointing about whether the SEC as a regulatory body can point to legislation that clearly authorizes them or authorizes the agency to require this degree of disclosure, the specificity of disclosure. And that would be under the Securities Exchange Act that the SEC would have to point to. And a significant Supreme Court case in a different context, but in relation to regulation of under the Clean Air Act, this was West Virginia v. EPA, ruled that the EPA did not have authority because there was not explicit language in the Clean Air Act. It's debatable, in my opinion, but the Supreme Court said that the EPA did not have authority to regulate that specific in the specific way in which it intended to under the Clean Air Act. And so this major questions doctrine is going to be something we read about. It's something that has already been mentioned, alleged, or almost even threatened from one political party in relation to the SEC's authority here. The SEC was established and has a mission, and that is to protect investors. To protect investors from behavior that we've seen that can be significantly damaging in the way of being materially misleading, not reliable. And the focus of the climate disclosure rule is to enhance, to hold accountable the disclosures in many cases that are already out there in the public space, but not in an SEC filing. And so to marry that breadth that you see in non-SEC filing climate reporting in climate reports or sustainability reports with what is in the SEC filings. Now, there was also reference to leapfrogging by the EU and the significant developments that have come out of the EU and continue to develop there. The Corporate Sustainability Reporting Directive, or CSRD, went final in January of this year. The EU process, because of the number of member states and the procedural and circular way in which rules are finalized, directives are finalized, it takes a while. But we got there with CSRD. CSRD, what I want to just kind of put out there, because I know we'll have a Q&A, is it does establish additional breadth to what a corporation, an in-scope company, would be required to disclose. However, in relation to climate, it has some very specific points that go beyond what the SEC rule would require. SEC rule would require, if a company has set these targets, to disclose them. CSRD would require disclosure consistent with the goals of the Paris Agreement and the 1.5 degrees Celsius goals of Paris Agreement in relation to, or a company would have to disclose what they're doing to meet that, to stay consistent with it, and year over year progress toward their transition plans for the 1.5 goal. But as the title of the directive reads, sustainability and not just climate, it is broader than just climate. I look to the rules coming out of the EU as quite meaningful, not only for EU domiciled companies, but those rules will apply and broaden the scope to companies not domiciled in the EU, depending on the amount of business in which they undertake there, the number of employees. And so there's a lot of exciting developments in the disclosure space. And then finally, the Corporate Sustainability Due Diligence Directive, or CSDDD, would require disclosure of supply chain management, risk identification, and progress to truly, as the Business Roundtable has said, that a corporation should do more than just take action in order to return revenue to its investors, but rather have a meaningful place in society around these topics of sustainability. So thank you for allowing me to try to compress a topic on which I have a lot of interest and am passionate about.
Thank you, Taylor. Mike, let's add to it.
So California is the 5th largest economy in the world. They're a very blue state. They have a history of issuing laws and rules that have a global impact, since everybody wants to sell into California. California, in the last month, has enacted 3 laws that are very relevant, that in many ways go beyond what the SEC would do, and therefore make it less relevant whether the SEC actually issues its rules or whether they survive, because they're going to cover most companies anyway. And there are also some little noticed regulations coming out, the federal acquisition regulations, that are also going to cover a lot of companies. So the first of the 3 rules that California adopted, statutes that they passed the legislature and signed by Governor Newsom, SB 253, the California Corporate Data Accountability Act, It applies to companies that have annual revenues of more than $1 billion if they do business in California. It doesn't require necessarily a lot of business in California, but some. It applies to both private and public companies. And so this is one way it goes beyond the SEC, because the SEC only has jurisdiction over public companies. But there's some very large private companies, the largest of which are Cargill and Koch Industries, that haven't had to report but will have to report under this law. It applies only to companies that were formed in the US, but one calculation was that it applies to at least 75% of the Fortune 1000 companies. It has no materiality threshold, so this is another difference from the SEC rule that'll bring in a lot more companies. And under this law, these companies must annually report their Scope 1 and Scope 2 emissions starting in 2026, and their Scope 3 emissions starting in 2027. Now, when Governor Newsom signed the bills, he said that he thought that maybe that was too fast, and he's going to ask the legislature to extend the deadlines somewhat. So regardless of what happens with the SEC rule, most big companies are going to need to make this reporting to California. The second new law is SB 261, the Climate-Related Financial Disclosure Act. It applies to companies with annual revenues of $500 million, as opposed to the $1 billion for the accounting rule. Also to companies that do even a relatively small amount of business in California, and to both private and public companies. And this has been calculated to apply to about 73% of Fortune 1000 companies. And this requires reporting consistent with the TCFD, which Taylor just talked about. Companies have to disclose their measures to mitigate and to adapt to climate risks. And this reporting has to begin January 1, 2026, and every 2 years afterwards, unless, again, it's extended. Now, these laws require the California Air Resources Board to come up with the detailed regulations, and there are a lot of details that they have to work out. How much business in California is enough? How do the rules apply to affiliated companies? Does it apply to parents, sister companies, and so forth? We don't know that yet. The regulations are going to have to clarify that. Which Scope 3 categories are covered? There are about 15 different Scope 3 categories. Nobody reports all 15 so far as I know. California Air Resources Board will have to define which ones. I think they're going to come up with rules to try to make this as consistent as possible with the European rules and the SEC rules, so you don't have a lot of conflicting reports out there. There may be some legal challenges to the California statute, but I think these statutes are considerably less vulnerable to legal attack than the SEC rule. The third new statute by California, and it's gotten very little attention, is AB 1305, the California Voluntary Carbon Market Disclosures Act. Now, we know that many big companies are making net zero pledges, and we know that most of these net zero pledges rely to a certain extent, sometimes to a great extent, on offsets. And there are tremendous concerns about the legitimacy of offsets. And so this new law applies to any companies that provide voluntary carbon offsets, or any companies that are making marketing claims, like claims of carbon neutrality, utilizing carbon offsets. And any of these companies are going to have to provide extremely detailed information about the nature of these offsets, and additionality and verifiability, and all of the other criteria for the legitimacy of an offset. There are a lot of news reports suggesting that there are a whole lot of offsets out there that would not meet these criteria. And so this new statute is going to have, I think, a very serious negative effect on the ability of companies to use offsets. It is effective this coming January of 2024, and Governor Newsom did not request a delay in that. So this is right around the corner. Finally, there is the Federal Acquisition Regulation, is a set of regulations issued by the General Services Administration and the Department of Defense and NASA that apply to companies that sell goods or services to the federal government. And under the proposed regulation that these agencies have put out, all businesses that receive at least $7.5 million in federal contracts per year will have to make Scope 1 and 2 disclosures. And all businesses that do more than $50 million in federal contracts will have to make Scope 3 disclosures. And the companies that do more than $50 million of annual business with the federal government will not only need to make disclosures, but they're required to develop science-based targets consistent with the Paris goal. Now, this is unusual. Most of these other laws say that if you have these targets, you need to disclose them and how you're going to meet them. This will require companies to develop these science-based targets. It does not apply to higher education institutions, nonprofit research entities, or state or local governments. The proposed rule would take effect for the Scope 1 and 2 requirements 1 year after the publication of the final rule, the Scope 3 2 years after publication of the final rule, and the science-based targets 2 years after the publication of the final rule. We don't know when the final rule will come out. Maybe they'll try to issue it at the same time as the SEC. And it's been estimated that it's going to apply to large swaths of business. 38,000 comments were submitted. So a lot of companies that are subject to it have really put in comments. So here too is another set of rules that, regardless of whether the SEC rules survive the inevitable litigation, are going to require most big companies to make a whole lot of disclosures in the next few years.
Thank you, Mike. So you see, those of you who are still in graduate school, courses in greenhouse gas measurement, understanding these rules, and corporate sustainability reporting will almost guarantee you lifetime employment. So give that some thought. And let's turn to Celine. Celine, why don't you tell us what companies are doing to prepare for this and how all of this is going to change and probably incredibly increase the business of your company.
Quite so. Thank you. Yeah, I think that's the headline here for students and prospective students and all of us in this industry is all of this is great news for us because there's a lot of work to do still. Before we get into what companies are doing right now, I wanted to just make sure you guys are with me because I know this time can be a little tough to pay attention. So quick show of hands. Who here is excited about the SEC proposed rule? Excited? Okay, great. Me too.
All the lawyers.
Who is a bit skeptical about the enforcement and efficacy of this rule? Okay, 50-50, still a majority. All right. Is there anyone here, show of hands, who thinks the SEC should not be involved in this at all?
It's a biased audience.
We're among friends. It might surprise you that once upon a time, I felt that maybe the SEC should not be involved in this. As a recent graduate of Earth Institute graduate program, it was self-evident to me that climate change is a systemic risk factor, and therefore, according to the existing rules since 1934, all companies should be reporting on all material risks, including climate risks. So when I entered into the corporate arena, I was maybe not surprised, but definitely disappointed to see that this view was not widely shared and that getting companies to assess, quantify, and report, especially on climate risks, was difficult. There was a lot of ostrich behavior saying, stick our head in the sand, we don't know how to do this, we'll wait and see. And in 2010, the SEC under Mary Shapiro issued guidance on how companies should be reporting on climate risk. And I thought to myself, great. Now we don't have to convince anymore. We can focus on doing, right? But that's not what happened. And I wanted to recount this because I feel that my initial excitement about the SEC proposed rule reminded me of this, that on paper, it's a pivotal, important change in the way companies operate and how they relate to climate information. Most importantly, putting it into their 10K alongside other material risk factors, right? So while I do think that the SEC rule in particular is extremely important and that it marks the beginning of integrated reporting, where pre-financial factors are taken into account in financial reporting, right? It might take some time until the effects that we seek really are realized, okay? So that said, what are companies doing about this today? How are they preparing for this potential SEC rule? Well, of course, the answer is it depends. Right? So I like to always segment my market. I think that's a helpful way to understand dynamics. And the way I think about this market is in terms of information users, reporters, and support services. Okay? So the information users are typically institutional investors who are the primary market for information in the 10K in particular, right? I would add, though, that these days in our stakeholder capitalism, rather, environment, the information users are broadening. So we're seeing customers wanting to access this information in order to calculate their own Scope 3 emissions and to understand their climate risk in the supply chain. We're even seeing suppliers wanting to know this information about their customers in order to assess whether their customers are in line with their own policies on climate change, right? And most importantly, perhaps for this audience, savvy prospective employees, right, are looking for this information to see how the companies that they're considering going to work for are actually handling these matters and how perhaps genuine the efforts are. Another thing to note here, okay, so those are the information users. Next, we have reporters, who are probably the ones that you would think of instinctively when you think of the companies that are affected by SEC rule in particular and these other rules that we've mentioned. And then finally, there's a whole ecosystem of companies that provide support services to reporters. I'm going to focus on the reporters and the support services segment in my comments that follow. But two other things before I get into it that are important to note. One, these groups are not always mutually exclusive, right? So a reporter can also be a user of this information, right? In the case of large listed financial services companies, for example. Another example would be a support services company. Could be, for example, a real estate management firm or a software provider who is providing services to many different publicly listed companies to fulfill these requirements, but also itself is a publicly listed company that has reporting requirements as well. Okay? And the second thing to note is that, of course, in each of these segments and subsegments, the maturity of companies' sustainability journey and particularly climate change programs varies, right? So we have the best in class, we have the pacers, and we have the stragglers, if you will, okay? So in terms of reporters, I think of three subsegments here. We've got large listed companies, we've got smaller listed companies, and then we have the non-reporters, who I think are also affected by this, okay? So let's start with the large listed companies. These are mostly companies that I work with. And in terms of how they're preparing for SEC rules, I think actually what they're doing is not so different from what they've already been doing, but how they're doing it is what is the main differentiating factor, and also who's doing it, okay? So what I mean by this is these companies typically have been under pressure from investors and other stakeholders to report to the CDP, to do greenhouse gas accounting, and in order to be best in class, they've followed the best in class standards and frameworks for climate change reporting. So they have a lot of the basics in place already. Typically, they'll have a solid carbon accounting, perhaps not all 15 Scope 3 categories, but many or most. Often these best-in-class large listed companies will also have annual verification of their emissions. So what's changing in preparation for a possible SEC rule in this regard, from what I see anyway, is carbon accounting is improving. So companies are really looking harder, applying more due diligence, saying, are we really doing this in the best possible way? And looking, if they haven't already been verifying, they're looking to verify these carbon emissions by a good third party, or verify to a higher level than they're already doing, okay? And another interesting part of this is I'm seeing companies either insourcing or outsourcing these activities. In certain cases where companies were relying on consultants to do their carbon accounting, for example, I'm seeing more companies hire an in-house person who really deals with this day in and day out. Conversely, we're seeing companies that have been handling this themselves, leveraging softwares, for example, and relying on external parties to do a better job, right? In terms of risk assessment and quantification, understanding whether the climate-related risks are material or not and worthy of going into the 10K, I'm seeing a lot of refinement in terms of the models in certain cases. And in other cases, actually, we're seeing a kind of play it safe model. There aren't really good verification standards currently for climate risk quantification. And therefore, many companies are relying on well-known service providers. And they can say, all right, this big company did our climate risk analysis, and therefore we have exercised our due diligence. Okay, so next I see more investment in certain internal data systems and accounting systems. So for the SEC rule in particular, there are two metrics that I'd say aren't explicitly covered in the TCFD requirements. And those are actual investments in climate change mitigation and actual damage due to climate change. And so you might say, that should be easy to find, but actually, there isn't a code in most accounting systems that says climate mitigation. So it's rather difficult to figure out what that total number actually is. So companies that are a little bit ahead here are thinking about how can we round out these metrics? How can we change our systems and improve them to improve the outputs and really make them solid, if you will. So all of this, of course, implies bigger budgets, more resources, and more attention. Next, I said also the who is changing a little bit. And so traditionally, this kind of information has been prepared mainly by the sustainability department, the CSO, and wherever that group falls in the organization, right? Now that we are talking about inclusion in the 10K, the CFO group, finance, and investor relations are getting more involved in this information. And these teams tend to be even more conservative than the corporate secretaries that are redlining our desired disclosures that we put out there, right? So this may have a bit of an effect on the level of disclosures. I foresee in the short term a little bit of a retrenchment, actually, from these large companies, getting a little more conservative in terms of what they're putting out there in their voluntary reports, so that there's no discrepancy between what they will put in their financial reports, 10K. Okay? So that's the large companies. The smaller companies, they're acting a little bit differently. This is kind of a wake-up call for many. They haven't been doing carbon accounting and risk assessment in the same way and reporting. And so for many, this is a kind of wake-up call to get started. However, for both small and large listed companies, I'm picking up on more of a wait and see attitude the longer we wait for the actual rule, right? Because they all know there's going to be a little bit of a ramp up period, and they're feeling maybe it'll be enough time to put together something that is adequate. Okay. Finally, non-reporters. These are the not publicly listed companies, private companies, right? I feel, or I'm seeing that these companies are also affected by this proposed rule. And what we're seeing, interestingly, is a surge in interest in carbon accounting, climate risk assessments from private equity companies, and to a smaller extent, VCs. And this is, of course, in anticipation for the portfolio companies going public at some point, right? Have to be prepared for the expectations of a publicly listed company. All right, a few small additional comments, and then I'll pass it on. So the service providers, right? This is my second segment that I wanted to drill into a little bit. Of course, as Steve noted, this is a great time for any company, big or small, working in ESG climate consulting. Huge surge in demand, right? As I mentioned, all of these companies, big and small, public, private, are all ramping in these areas. And of course, this is causing a lot of increased business. Now, it's not only the usual suspects, if you will, that are ramping up. So in addition to consulting firms, both large management consulting firms and smaller boutique firms that are more focused on ESG type disclosures, we're seeing the Big Four accountants really ramp up their expertise in this area. And also, we're seeing all different kinds of service providers from all around the economy that have any kind of touch point with this information, ramping up their service offerings in order to capture a piece of this market. So you're seeing real estate management companies, you're seeing energy services companies, you're seeing software companies, legal. Everyone is ramping up their capabilities in terms of these reporting functions. And so we're seeing a huge surge in training, investing, and actually the bigger firms acquiring the smaller ones. So those are some things that are happening in terms of companies responding to this SEC proposed rule. And as you can see, it's really affecting companies throughout the corporate ecosystem. But what it all will really depend on, I think, is the information users. and to what extent they demand this information. And so we shall wait and see what happens.
Thank you, Celine. And to provide a little bit of perspective from the organizational management perspective, 20 years ago, nobody was paying attention to any of this. Okay, it didn't exist. And so this is a management capacity to think about and measure and report on environmental impacts that literally did not exist before. And so it's very exciting, especially if, like, some of us were in the business of educating people to learn how to do this, because all this ramping up, nobody knows how to do any of this stuff. So it's really useful that, you know, we have courses in life cycle analysis or greenhouse gas measurement or corporate sustainability reporting. So the next area that I wanted to touch on is all of this is, in many respects, has to do with investors and with markets. And so I've been talking about the law, I've been talking about the companies. Now we have an expert who knows actually something about financial markets. So Professor Bose, if you could tell us, what does this all mean financially?
Sure, yeah, thank you, Stephen. Thank you very much to everyone else for setting the stage. Sorry, I should turn this on, right? Especially since my cough is. All right, that should be better. Thank you very much. So, you know, Taylor and Michael laid out the legal aspects of it in the US and also in the EU, as well as in sub-jurisdictional regulations like in California or through federal government contracting. So we can see that there is this push for climate disclosure throughout. And Celine showed us how much work is involved for issuers, for reporters. But all of this is really being driven by the investors. You know, the investors have been asking for this information for a long time. If it wasn't, you know, if it was just up to the reporters, they have no real incentive to release that information unless the regulators ask for it. And the regulators have been pulled to start regulating by the investors. And I want to give you the reason for that. You see, financial markets work best when there's transparency. They only work through the flow of information, and they work through the availability of standardized, comparable, reliable information. So the moment that in the investor world it became clear that climate was a systemic risk, and it's not just, the issue is not just that it's a systemic risk, but it's a systemic risk that can be dealt with in different ways in different industries by good players, bad players. It's important to be able to distinguish between different issuers, and you can't do that unless you have standardized information. So I think, you know, Celine showed us that a lot of the information, Scope 1, Scope 2 emissions, are already being reported in sustainability reports, right? So why do we have to pull teeth to have an SEC climate disclosure rule? Well, you know, there's research that Professor Cohen and I cite in our book. It shows that if you took a sample of companies in France in 2015, and France was already early in reporting carbon emissions, you'd find that the median emissions reported by these companies on their sustainability reports was 76% of the amount that they reported on their CDP reports. The CDP reports were confidential reports issued to a subscription data provider as a result of a questionnaire. Sustainability reports are voluntary, and there's no particular regulator that looks at them. And so it's possible to be much more vague and just miss out on some emissions when you reported on them. So something as simple as Scope 1 and Scope 2 emissions. I mean, I know that we have whole classes on teaching how to evaluate them, but it is something that we can teach in 1 or 2 semesters. That is not easily and consistently released at the moment. And so that's why we need that level of transparency and that level of regulation. The other piece of it that I want to highlight is that only when you have this kind of information across the universe can you actually start to benchmark the people that you invest in, the issuers that you invest in. So it doesn't help if 75% of the Fortune 1000 are reporting. If I'm looking at a sector where 50% of them are in the Fortune 1000, but then another 50% are not, or they're in other countries, or the supply chains are either private or in other countries, right? So the benchmarking is what's needed. So something like the SEC Climate Disclosure Rule allows that. In the EU, the CSSRD does that. But also, there is also the International Sustainability Standards Board, and this year they issued 2 standards. I think it's called maybe S1 or SF1.
IFRS S1?
S1, S1 and S2, right? S1 and S2, which lay out standards comparable to the SEC disclosure rule, in some ways a little bit deeper and in some ways a little bit wider. I would also note that it's not just a sort of US versus EU competition. One thing you should know about the US capital markets is that as a net amount, most of the capital in US capital markets come from outside the US. The net investment position of the US, the net international investment position of the US at the end of June this year is a negative 18 trillion. So that is the net of approximately 45 trillion that is owed by US residents to investors outside, minus about 28 trillion which is owned by US investors outside. So that negative 18 trillion means that capital is coming in from the US. So the US no longer has the luxury of deciding what to allow to be disclosed or not disclosed based on any parochial rivalries there might be in a political context between California and blue states or red states and so on. I forget what each of those things mean. But so just to give you the international perspective on this, if the US does not provide good transparency, then its capital markets will lag behind those of the EU. The Hong Kong Stock Exchange issued the same kind of climate disclosure regulations, and they will kick in 1st of January 2025. That's after a 1-year delay. And the Japanese regulator is considering the same thing. Singapore is considering that. New Zealand is considering that. And China has made a statement that they will incorporate the ISSB S1 and S2 into their disclosure regulations. So it's in that world we have to compete for capital. In the sort of 30 years of my time in financial markets, I started working in investment banking in 1994. 1994 was 5 years after the collapse of the Berlin Wall. And in that time, we saw that capital essentially got domiciled in New York. People would have savings Rich people in Brazil would park their savings in New York. They wouldn't park their savings in a bank in Brazil. The same thing in China, the same thing in Japan, Saudi Arabia. The savings of the world ended up being invested in the capital markets in the US. We cannot count on that anymore just by virtue of being the US. The product offering, the capital markets product offering, has to be at least as good as everywhere else in terms of transparency and being able to meet the needs of investors. And why do investors need that information? Because they're looking to design financial products which allows an investor to direct capital towards decarbonization, towards activities that limit climate damage, that maximize climate opportunity. And you can't do that without this type of uniformity. So, I mean, there's a lot I wanted to say, but I think, we should give time for questions.
It's a complicated story, but let me first, before opening this up, I want to provide a little bit of context, because this is about having a cleaner environment. So why does disclosure matter? Well, to quote Professor Apson, who's in the audience, in order to manage something, you have to measure it. Without measurement, you can't tell if things are getting better or worse. So we need these measures. But the other thing is that the idea is that by disclosing, it'll be an incentive to corporations to reduce their pollution. I mean, that's the sort of hidden message here. So Professor Gerard and I have been working in this field for a long time from the perspective of government regulating industry to reduce pollution. So the whole structure of American environmental law, going back to the Clean Air Act and the Federal Water Pollution Control Act, was to provide rules that companies had to follow to reduce pollution. But it turns out there are many ways to encourage companies to reduce pollution. One of the ways is command and control regulation. Another way, turns out, are these reporting requirements. There's also tax credits, other kinds of incentives, public shaming of corporations. There are a variety of techniques. This is one of them. And it turns out, and I think this is what I'm so persuaded by listening tonight, and I hope you're persuaded by, is this is incredibly powerful, because it goes right into the organizational structure of corporations. Now they have to build capacity to understand their pollution. And the people that are doing that, it's sort of like, and I think about this, the role of CFOs in organizations, and they didn't exist before the 1930s, but it taught organizations to be very careful about their management and financial control systems related to money, okay? If the same thing happens with environmental impacts, the organizations will now have the capacity to understand and hopefully reduce their environmental impacts. So before we open it up to questions, I want to just ask the panel, do you think this stuff's going to result in a cleaner environment? Why don't we start with Mike? We'll go down the line here.
I do, and one sort of proof of concept is, back in 1984, there was a horrible chemical accident in Bhopal, India, and several thousand people died in a Union Carbide plant. And a couple of years after that, Congress passed a law called the Emergency Planning and Community Right to Know Act that required companies to report the amount of chemicals they were using and releasing, so the toxic release inventory. Many companies really didn't know. They had to do the calculations. They didn't realize what were the sources of pollution from their various factories. Once they found out, many of them were horrified and took steps to reduce it. So they hadn't been measuring it, but now that they did measure it, they figured out ways to reduce it. And various NGOs took the publicly reported number and started ranking companies by who were the biggest polluters. And people didn't want to be the biggest polluters. They didn't want to be on top. So they adjusted their behavior to move further down the list. So that law is similar to this in many ways, and really demonstrably had an effect on lowering releases of toxic pollutants.
Taylor?
Yeah, I would say a reporting directive or requirement instills in companies the obligation to mature the programs that probably already exist at some stage. I believe that a number of companies that report in voluntary disclosures have dedicated resources, have attempted this or approached it in good faith. However, the additional rigor that naturally is triggered when you are going to have an opinion, meaning a legal opinion supporting the accuracy of the disclosure in an SEC filing, causes a company to ask questions that arguably should already be asked about the validation, the sourcing, and overall the accuracy of these disclosures. I compare it to a scenario that I live in my life as a father of 4 young kids. All of our kids, we try to instill good money management skills. It doesn't come naturally, but they're at different stages. Once I start like holding them to a specific, okay, if you blow through your budget, you're not getting any more. They really start paying attention to where their money goes. And so if
So it's like a pollution allowance we're talking about.
I haven't thought of it that way, but I think companies and at the top level of organizations will have discussions, will conduct the vetting, which will improve the disclosure and improve the overall performance, meaning emissions performance of companies.
Okay, Celine, is this going to make the environment cleaner?
I think so. So firstly, I agree with everything that was said so far, and I won't repeat. I think it goes a little further still, potentially, especially when you look at the risk management component. So there's, of course, the GHG management, right, we've already spoken about. But I think really understanding climate-related risks and the process of doing this properly has the potential to change the way the companies think about their operations. And this can be really transformative. And I have worked with companies on the risk identification and assessment and building that into strategy and operations. And I've seen that the transformation basically from ostrich behavior, we don't know how to do this, we don't want to know, to, we have some areas where we have a problem and we have some areas where we're actually doing really well. And how that information around climate risks or broader environmental or social risks can start to change the way that companies operate and their strategies. So I think it has huge potential.
Tasha, it's going to help us clean the environment.
Yeah, well, as an economist, if you put a price on something, then you pollute less, right? So in many ways, one of the less discussed aspects of the disclosure rule is that it requires companies who have targets towards transition to publish their internal carbon price. And that's very important because many companies do have those internal carbon prices, but some of them are very low, like $1 per ton, and some of them are very high, like $50 per ton. And so knowing that will already make changes. I think there is also in the asset management industry quite a lot of greenwashing that comes about because of the lack of comparability. You have funds that claim to be investing in decarbonization companies when they actually aren't decarbonizing in any real way. The comparability of the data will eliminate at least that source of greenwashing. So it'll be possible for an investor to invest in companies that really are decarbonizing. So that will reduce the cost of capital for those companies, and it will make it a more attractive financial investment to decarbonize.
Thank you, Sir Tasha.
Can I just throw in one other thought? One other requirement of the TCFD requirement is disclosure of the physical climate risk. And I think that's one thing that many companies don't look at closely enough. And we've had a couple of years with unprecedented wildfires and heat waves and droughts and floods and so forth, which are very substantially affecting a lot of supply chains. And it's all going to get worse. All the projections are all of this is going to get worse for years to come. And I think that these disclosure requirements are going to make companies think much harder about the extent to which they have this physical climate risk. And hopefully, when a lot of them wake up to this, they will persuade their representatives in Congress that they really have to do something about this and not just talk. And so hopefully it'll have that secondary effect and get us some of the laws we really need.
Sounds like a plan. Well, at this point, we're ready to take some questions. I see Chandler and Sarah have microphones, so if you have a question, raise your hand and they'll come to you. I see one up here. And please, let's make it a question and not a statement.
I'll try. Thank you all so much for the amazing talk. I just wanted to start off with one of the first points. When you talked about the political element of some of these regulations. So to what extent can the regulations institute permanent change, given, I suppose, the febrile political mood regarding, some of the ESG conversation for the most part, So is there a bit of a tension, if you will, between the proposals and, the political scene?
Okay, anybody want to take that one?
Well, depending on who wins the next presidential election, we could well see a rollback in the SEC rules. We won't see a rollback in the California rules. And so they're going to stick regardless of what happens. So the federal rules are in some flux, but the state rules and the EU rules, the EUs have their own flux capacity. But the California rules, I think, are really going to be a backstop that's not going to move.
Yeah, and
The good news is many companies have to operate in California.
Right.
And so all you've got to do is operate there.
a key difference between California and what the SEC is doing is California, that is the state legislature, so that is a statute as compared to a regulation. And in the legal world, we broadly define what is a law, and certainly regulation fits within law. But legislation, has the ability to withstand executive action, and so you wouldn't have that potential rollback.
Okay. A question over here.
Thank you so much. This is really exciting. The stickiness of all of this is especially exciting. The fact that there is momentum, these disclosures are coming basically in one form or another. So my question really is about how institutional investors, I hear you that transparency is important, making things comparable. I'm coming down from the business school. I'm actually new to finance. My background is in environmental disclosures, but there are ratios at which things will be uninvestable, or there are very specific benchmarks when you're looking at a financial statement. You would say this is completely uninvestable. So I guess I'm curious, do you see institutional investors setting budgets in certain asset classes or sectors, carbon budgets that is, or looking at benchmarks under which nope, that's uninvestable? And I guess how are you building those, or not you specifically, I'm sorry, but how are institutional investors building those processes, the adequate skill sets for people coming into those roles, to do that work? Because I think it's time.
We're having them come to our programs. But Taji, why don't you take that one?
Yeah, sure. We've seen this a lot, and it's been going on for a long time. So the push for, in our program, the Sustainable Finance Certificate was developed coming out of institutional investor workshop that started in 2012. A lot of the discussion around private equity, why are private equity companies so interested in this disclosure, even though the SEC doesn't affect them, is because of the work by limited partners, the institutional investors acting as limited partners in private equity funds. There is a lot of metrics currently being utilized to slice and dice the universe of investable issuers. You'll hear metrics like the warming potential of a portfolio, or the Paris alignment of a portfolio, or the carbon intensity of a portfolio, and that can mean 6 different things. So that type of analysis is discussed by lots of investors, lots of data providers. We have some alumni here who work for data providers who built some of the models around that with competing metrics. So it's a competency that's being developed and also being refined as we speak.
See a mic over here, go ahead.
Sure, did you have something else, Celine?
I wanted just to add that we can see this also in the transition risk or all of the risk analysis and assessment. You can look at it on a company level or you can look at it at an industry level. But the TCFD, which is really the root of all of these different disclosures, really talks about how both physical risks and transition risks affect assets, liabilities, expenses, and so on, right? All of the financial balance sheet metrics. And so you can start to model out, a simple example is the external cost on carbon. You may have an internal cost, but the external costs we're seeing, they're going up finally. And just as an example, in carbon intensive industries, if companies there are not decarbonizing, it could have a real big effect on profit margins. And so right there, you can see how that would become a less attractive investment or perhaps even cause a company like that to go out of business eventually if prices go too high. So the risk assessment is an important component there.
Okay, go ahead.
Thank you. I have a question talking about the transparency and accuracy of the data and how important that is. And comparing it to financial markets and how financial markets have financial auditors who are looking at this at a certain level of assurance. What do you see the future of auditing within the sustainability world? How do you see that developing?
It's a capacity that has to be developed. And you are starting to see some of these accounting firms hiring people they see this as a growth business and they want it because if you're on a corporate board, you know, the SEC rules are really important part of every quarterly meeting. And the disclosures and the form of what you're saying, the way the financial reports are being issued. And they have that business along with other firms that do that. So you're going to see those firms trying to build in that capacity. One of the problems they have, frankly, is they don't know how to do it. If you watch them doing it, it's horrifying. You know, I want to give them Celine's phone number and say, you know, she's got people who know how to do this stuff. The degree to which this technical requirement is coming in is going to be massive, and the technical capacity to do it does not exist yet, is pretty impressive. So it's going to happen, and it's going to, and you know, you see a lot of these rules are gradual, 25, 26, 27. So there's time to ramp up. But I consider this the Environmental and Sustainability Management Full Employment Act of 2023. I think it's going to create enormous amounts of work, but it also puts demands on our curriculum here to train people to understand these issues, and it's happening. I mean, you can see it gradually taking place, but the capacity's not here yet. I don't know if anybody...
Yeah, I want to jump in there because, you know, our program has constantly had to evolve from 2010. You know, Steve talked about founding the program in 2010, but you know, we have alumni who graduated in 2011 who come back and they say, I can't imagine the courses that are now on offering. And right now, as a result of the proposed climate disclosure rule, as a result of the EU regulations and the Asian regulations, we've had 4 or 5 new courses designed specifically for that. Professor Goa and I have been a little bit slow in our courses being released in the spring, talking about the risk identification part and quantification.
Okay.
And there's so much interest in the law school that we have 3 different courses on ESG now, in addition to my basic course on climate change law.
So you're no longer lonely there, Mike.
That's right.
Other questions? Over here? Okay.
I'm curious about, are you guys aware of any other states adopting California type regulations?
New York is proposing them.
Yeah, there's a bill pending in the New York State Senate. And there's some discussion on others, but the New York one may
Looks
happen.
close.
Yeah, State of Washington is rumored as well, as they did with LCFS. They modeled their low carbon fuel standard after California, and it's expected.
And then the
Washington
corporation is
will
going to
follow.
beg for the SEC to put out a national rule that covers everything, you know. it'll be kind of interesting.
But you
to
think
see.
there are a couple really significant issuers headquartered in the state of Washington in the tech space, and so I think that's driving some of the activity there.
Let's take a couple more questions before we start refreshments. I see them starting to unwrap them. Go ahead.
Thank you so much to all the professors for this really insightful event. My question is in terms of the energy transition. If you think that the disclosures that the SEC is going to be putting forward is going to kind of stagnate it a little, because some mining companies are going to be a little skeptical and trying to disclose really what's going on behind it, or is it actually going to be helping it and moving it faster? Thank you.
Anybody want to take
Yeah,
that?
I'll say one thing. I think because of the incredible incentives through the Inflation Reduction Act, there is a boost to the level of activity that we're seeing toward the energy transition that would be very difficult to derail. And I think that even a conservative approach to disclosure is tough to overwhelm the financial incentives available through the Inflation Reduction Act to make investments that produce a lower carbon economy here in the U.S.
Okay, let's take one final question over there. Go ahead.
Yeah, thanks for a really interesting panel. The question that was asked by the woman in the second row earlier, I wanted to unpack it a little bit further as someone who's more coming from the climate risk perspective. And I think you touched on it in response, Steve, but I don't really fully understand like what corporations are expected to report when you've got sometimes very long tail risks from different types of climate related extremes, whether it's cyclones or extreme rainfall events. Maybe your facilities are distributed all over the world in different locations with very different exposure levels. As a geographer, I'd be interested in that. And then, then what do? Do you actually sum it up in some numeric terms in dollars and cents and say, this is what my overall risk? So how do you incorporate the PDFs of these different extremes, and then somehow, it sounds like it's really, like you say, it's complicated, and it sounds like nobody's really done it well yet.
You have to take our class.
Celine, this
okay.
this sounds like a question for you to take.
Yeah, so the quick answer is yes. You summarize in terms of physical climate risk and transition-related climate risk. Those are the two big numbers. And you only report them for the SEC rule if they are material. So if they are above a certain threshold, right? And then in addition to those, the rules require some explanation of how you've done this analysis, right? With different climate scenarios, both different temperature scenarios and different time horizons, right? Long, medium, short term. And the rules lay out pretty clearly these parameters for analysis, and require really a rolled up number or two numbers, total physical risk and total transition risk identified. And so the nuance is in how much information companies provide around what they've done to analyze this. And so this is good news, right? And as you say, not many companies have done it well or comprehensively, and there's a lot of work to do here. And even the companies that have done it somewhat well will have to keep refining because conditions change. And so this is a very fruitful area if you're interested in it.
And we've spoken quite generally about the requirements. There's a lot of granularity to these requirements. I mean, I think everybody's been nodding their head because the policy behind this makes a lot of sense to me, and I sense that from the audience. But when you consider, just for example, if you're reporting your greenhouse gas emissions, the requirement that you report the aggregate number as well as disaggregated greenhouse gas emissions. If companies can't name the 7 greenhouse gas emissions by name, how are they going to report them other than methane and carbon dioxide? So there's a lot of specificity in this rule. Maturing needed, probably outsourcing of technical support, which I guess I'll wrap up by thematically hitting the point of a lot of opportunity in this space for people who train themselves.
And the history of measurement, if you look at labor or economic measures or census measures, they are constantly evolving as we learn more about measurement, about reliability and validity, and we learn more about the world around us. So this is going to be a moving target. So I'd like everybody here to join me in thanking these experts